My name's Steven. I'm the Vice President of NAMC. We'll also be joined by Will Trin, who's coming in now. He is he's going to be the actual host for the New Haven Virtual Tournament. So he's the one who's been organizing things. Who you've probably been emailing. I think he just popped up in the room. So if he wants to say anything quick, he could feel free to introduce himself formally.
Yeah, hi y'all. I'm Will. I'm the New Haven virtual host, and sorry, my voice is low key kind of dead right now. But yeah, if you have students who are at that tournament, you have been mostly contacting me. But yeah, feel free to always contact me if you have any questions for the tournament upcoming next Saturday.
Uh, And just to run through the day, we're first going to quickly cover judges' ballot, then some roadmaps, then hypothetical questions, and then final tips and questions, just to kind of wrap everything up. First off, your ballot. Will, do you want to take this one, or do you want to rest your
Yeah,
voice a bit?
Yeah, I can take a judge's ballot. So, quick thing about ballot breakdown. So, there are three things that are on any judge's ballot. The first thing is the content of argument. So, the content of argument is something that you're grading exclusively on the oralist's ability and command of the record. So, do they have an understanding of the cases that are being debated? Do they have an understanding of the record and how that is being implicated? And how they are focusing on a central legal issue, whether it is issue one or issue two. So we have a scale from 0 to 20. We would please recommend anybody not like scoring anywhere below 14, I believe. 20 is, for example, somebody who is very exceptional, but we would recommend not to like deflate any points beyond below 14, simply because for anything below 14 would be a little too low on the scale. Let's see here. The Let's see here. The second thing is extemporaneous ability. So part of moot court oral argument is being able to answer questions on the fly. So, for example, the biggest thing, so there's three things for this. The first is being able to answer questions and not having to read off the script. This is particularly important for a lot of like in-person tournaments, but it can also be important for virtual tournaments, even if you, for example, like it is probably hard to uh stop students from like reading or like stop you guys from like reading off a script in the middle of an online tournament. But like asking questions is how we as judges are able to think are allowed to think, okay, do students understand the arguments that they are making, and that can they answer arguments on the fly? Uh, and another thing about extemporaneous ability is the ability to respond to arguments that have been made by the opposing side. When you are giving an oral argument, you're not giving an oral argument just to the judges. You're also in conversation with the other team who is also in the room. So if the opposing counsel is mentioning something, you should probably be taking notes and making note and then referencing those things in the speech. The third thing, and this is like more of an arbitrary category, but still an important category, is forensic skill and courtroom demeanor. The Basically, this just records whether or not you have proper respect and courtesy towards the court and opposing counsel. So the first way to like think about anybody who loses points to this is like, for example, let's say you are a petitioner and you forget to reserve time explicitly for rebuttal. Then judges would often be instructed to take away points if you forget to instruct how much time for the bailiff or whoever's in the room to for rebuttal. So oftentimes, so like it is important if you're a petitioner to remember to reserve time for rebuttal, and it is always good to begin your presentation and to begin your speech with "May it please the court" or some other honorable introduction before you begin. But yeah, those are the three main parts of any ballot.
Thank you, Will. Thank you so much. So yeah, you'll be judged, but somewhere between one and three judges during the preliminary rounds, possibly up to five on the final rounds in different regional tournaments, and that kind of ballot adds up to your score, but averaged across however many judges you have for a round. Moving on though, let's actually talk about how you actually make these arguments, and really discuss roadmaps, which are this really key to organization. So This is just a blurb. You can read it kind of as I speak. But the idea of a roadmap is that you know what you're saying. You've practiced this for weeks. You're going to be an expert at this. Judges have no idea what you're going to say. We don't know what arguments you're going to make, the order you're going to make them in. We'll have an idea, especially as we get later to the day, but we don't really have an idea of what your specific argument is, or the ways we should really be thinking about this case that you're outlining for us. And because this is an interactive activity, because we ask questions, we interrupt you, we kind of move you off your pace. A roadmap is a way for everybody to kind of still somewhat keep on track. What can a roadmap look like? It can look like all sorts of things. I know a lot of people who will write out a speech detailing all of their points, both from NAMC competitions who have written out speeches that do really well, to kind of our former captain last year who would write down everything she'd say and she wouldn't use it as an exact script, but it would be a way for her to think about this issue, so a way to formulate her argument. It can also just be a page or two of bulleted points. The most cramped, dense note that you can think of, just phrases and bullet points, if that's what helps you think. I personally like to have a collection of quotes and phrases, Maybe I have a particular quote from a particular case that I think really emphasizes this point, or a specific footnote citation I want to have. I might just have the quotes and none of the content around it or arguments around it because I trust myself to be able to remember that and make those arguments. And I just want to reference to make sure I'm quoting a quote exactly. The point is, a roadmap can be literally anything that makes sense to you as long as it is not the only way you have of understanding and delivering your argument. And this is kind of the key thing to keep in mind with a roadmap. It's a to-do list, not a script. At its core, moot court is a conversation. You'll hear that 100 times. And a lot of the kind of difficulty of this activity is making sure that you're speaking with your judges and that you're getting them on your side because they're the ones that will ultimately decide this case. And this is as true for all arguments at the appellate level or the Supreme Court level in real life as it is in this activity from high school up to law school. Because of that, you don't necessarily want to have a single way of going about your argument and not be willing to deviate at all from it. In the case of this instant case, if you were able to say, if your judges immediately concede and are convinced that there is a common law equivalence to the actions of the National Labor Relations Board. It doesn't really make sense to spend 5, 6, 7 minutes arguing that, right? You've already established that point because judges already agree with you. You're sort of just wasting your time that could be used for other points that they might not necessarily believe. Likewise, if you have a particular point that you were originally only planning to slot a certain amount of time to, but you can tell judges still aren't convinced, it might be a thing where you have to answer more questions on it and spend more time on it than you otherwise want to. In that sense, you should think about your major pawns in your map, the 2 or 3 sub-points you have to make in order for your side to win, as a to-do list of things you have to check off, but that might be checked off by judges themselves or might take different times to check off. It also means that you might be able to move between different points. It might not be a thing where you jump to what was originally supposed to be a point 3 because that's what the judge is asking you about. So some final tips and tricks with roadmap. Be This is kind of a really important point. Whatever you do, never say I will address that later in response to a question. Kind of fun part about this activity, you talk about whatever the judge wants you to talk about. They're the ones scoring your ballot. They're the ones determining whether you win. So if a judge thinks this is important, that's what you have to talk about. And if they do break you from your order, it's nice to kind of reference the fact that you do have a roadmap that you introduced at the beginning, but you should still be willing to kind of move from that script and to go to that second point. You should, though, signpost frequently. These or arguments get long. These days in tournaments can be long and tiring. And when you do signpost, it allows us to keep in mind what arguments you're making, kind of the order you're trying to make them in, and what really and how really you're thinking this case should be structured. Quite literally, say, this brings me to my first point. Now on to my second point. Finally, on to my third point, and then repeat your same prompt that you had in your roadmap. You can also use questions to transition between points and be clear that you are kind of still referencing your roadmap when doing so. So instead of saying, I will address that later, never say, I will address that later. You can instead say something along the lines of, yes, Your Honor, your question actually brings me to my third point. Da 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 da. You answered the question briefly, and then if you need to go back earlier, say, now returning to my first point. This is just going to be a lot of memorization and muscle memory and control. But if you can think about your roadmap less so as an exact script of things you need to do, and more so as a to-do list or list of objectives you should carry out, I think that's the big difference between teams that can make it really far in these tournaments. Now, onto my favorite activity, answering hypotheticals. We're going to take a bit more time with this one. Um, just because I have some very funny quotes that I quite love. So overall, if you have any experience with moot court, you've probably sat in a round where you're asked some ridiculous question that is completely separate from the instant case and really doesn't seem to make any sense. This is because of the kind of nature of this activity. The way the Supreme Court works, and thus the way oral argument works and our simulation of it. The Supreme Court's role is to generate precedent that applies not only to this instant case, not only to what we're talking about right now, but to all future potential cases. And it's really kind of a bit of a logical game. You're developing a rule which, when applied to the instant case, results in your side winning. Or you're explaining why a past rule should be applied in a specific way. Usually something that slightly alters or changes or enhances our understanding of it. Either way, you're giving the court a specific framework to use when they think about this constitutional issue. But because of the fact that we're generating precedent, it isn't great that the rule just means that you win in this case. It has to be something that the Supreme Court would be able to be used in the future. And it's also something judges want to think about because this kind of helps determine how logical, how well-grounded and precedent your rule really is. The job of a hypothetical is thus to test your legal rule and see how it applies to edge cases. You'll probably be asked hypotheticals, definitely at least once, probably multiple times, and they can get very, very weird. And not just at the moot court level. Let's listen to the Supreme Court.
I take it you're using this because I was going to ask you. That are going to have genomes in them that could at some point lead to tomato children that will eventually affect Boston.
Tomato children, a very, very real issue that the Supreme Court has to consider. Here's another example.
Thompson, now suppose there's a grandmother that's keeping a suitcase for her grandson, who's the mule, and it contains cocaine. He's gone for the weekend. She keeps it for him. Life without parole, right?
Yeah, these questions could get very weird. They can get very silly at times. But the point of them is to kind of generate these ridiculous edge cases that you wouldn't normally think of and see kind of how your rule or how your application would react to that. If there's one thing you remember from this recitation, it's this. However you respond to hypothetical, do not fight it. Do not say, oh, that's not this case. Do not say, well, that's not what's happening now. do not say we don't need to worry about that. First off, it comes across as a little condescending, like, yeah, we're judges. We know less about the cases than you do, but we have like read some of the record. We know what we're saying isn't the case. That's why we're asking you about it. More broadly, though, it kind of creates the impression that, oh, this answer's bad for you, or you don't know how to answer this question. That must mean that your rule itself doesn't work, right? Because if you're telling me I have a rule that I should win because of this reason, and I say by that same reason, wouldn't this thing happen? And you say, well, that's not gonna happen because we're actually in this case. I have to question really how good your rule is. Once again, it's not just NAMC judges that have a problem with hypotheticals. It's not just collegiate or law school level judges that have a problem with fighting hypotheticals. It's a very tempting thing at every level, and Supreme Court justices are no more friendly to it. Uh, s-
Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it.
and I'll say this even goes if you initially fight it and then try to answer it anyways, because this is a limited activity. We have a limited amount of time. Some judges are going to be trigger happy. Um,
Would you say that the statute would necessarily be unconstitutional in its face if this was really a drug kingpin and everybody admitted it?
That would be a closer question. However, I don't believe that
Well,
mandatory
how did
life.
you answer the close question?
It's also just sort of wasting your time. You have a limited amount of time to make the points you need to make. So saving yourself as much of your time as possible by avoiding having to be re-asked something or challenged about something kind of makes everything go smoother. Why should you answer a hypothetical question? Well, when you think about it, any hypothetical question, anytime a judge says, well, would you win if this were to happen? Or what if this were different? Or what if this were different? They're really saying one of three things. First off, your rule is too big. That based off of your argument of how we should think about the First Amendment or the Seventh Amendment or the unitary power of the executive to control communications with subordinates, that we are going to allow things to happen that we do not want to happen. So if you were to ask, in the case that you guys have before us, if you were to be asked, well, under your rule, wouldn't a president be able to directly tell the Attorney General's office or a like lower deputy attorney to prosecute a mayor that he's unhappy with or a representative who's stonewalling his agenda in Congress? They're basically saying that your rule, your application is going to allow things that obviously shouldn't be allowed to happen. Um, Oh, sorry. To be clear, by your rule, I quite literally mean your basic argument. So if example of First Amendment, rule would be Congress can pass laws that regulate speech in a specific time, place, or manner. That means that when there are specific, that Congress can't control the content of what you say, but if you were to be at a specific place, if you were to be in a specific time, they can say you can't protest at 2 a.m. in the middle of a residential neighborhood. They can't control what the protest says, but they can't control that. That's one example of a rule. Another example of a rule would be in the case of the census case, with the idea of trying to think about it to say this, whether or not a law that is a punishment or a if a federal executive agency or one of these adjudicative agencies punishes you with a fine that is punitory rather than somehow remunerative or something else, that is unconstitutional. And then maybe it's something about anything that is more than the express financial cost to the party is actually punitory. So if it's just back pay, that's fine, but anything other than back pay is punitive. That would be a rule of some sort. So saying a rule is too big would be, as I already explained, your rule allows things that doesn't happen. If we really say that the president can speak to any one of his subordinates, you're going to allow things that shouldn't be allowed. Your rule is too small is the opposite of this, but it's also one that deals with the size of your rule. So in this case, going back to the example of any payment outside of back pay that the NLRB kind of forces somebody to pay is going to be punitive. Well, that might be too small. You might think of examples of, well, counsel, hypothetically, what if in addition to like losing their job, I guess in the instant case, they also lost health insurance and they suffered a grievous injury during that time, that they would have been protected and had they retained their job. Is that really punitive to force them to pay that? Or let's go, something even smaller. What about if you were to say that, um, so it's just basically, your rule doesn't capture something that we might want to happen. Going to a First Amendment claim, if we were to say, you guys are all somewhat familiar with free speech, true threats aren't allowed. This is from a NAMC case a couple of years ago. You cannot like threaten somebody or bodily harm. If you were to if you were to make a rule that says you have to specifically say, I plan to go to your house at this time, at this instant, and I plan to inflict harm on you for these reasons. And if you don't do that, that's a true threat. Well, that clearly is too small. You can imagine tons of scenarios in which somebody does come to you and says, "Oh, maybe somebody will do something about it. I don't know." Ha ha ha. That should still be a truth that should still be barred by the Constitution, but that wouldn't under your rule. And this final thing is a bit of a different from the past two kinds of hypothetical questions. And it just suggests that your rule is unclear for whatever reason. It's lacking in clarity. They don't understand it. They don't know how to apply your rule in the future. Just tackle with the first kind of question, because there are these two categories of size questions and clarity ones. There are two good ways to answer this. First, the outcome is bad, but your rule won't allow it. In this case, you tell the court, actually, you're making a mistake about the size of my rule. Um, under our rule, that wouldn't actually happen because this is the limit to it. Because when we say that any pay above back pay is punitive, we're also including kind of the compensation from health insurance or other types of benefits. In that sense, you first concede that the court would decide differently under that hypothetical. Hypothetically, Your Honor, if NLRB only paid for his back pay and also a bit of a stipend to cover the cost of his medical insurance while he had lost it, then we would lose. As a note, it is always okay to concede that the court would decide differently under a hypothetical. There can be this tendency to think that you have to defend every point and you win in every case, no matter what the facts are, and that is just ridiculous. Nobody's gonna win always, or your side isn't gonna win always. And if the facts are different enough, then there's a pretty good chance that the case would be decided differently. You don't need to win under every possible iteration of the current case. You need to win under this case with these rules. And conceding that under different circumstances you lose can actually strengthen your initial argument. So you concede that the court would decide differently under that hypothetical. You explain why applying the same rule leads to different results. When we say that anything is punitive unless you're solely talking about compensation, well, medical insurance is a part of compensation. Something like emotional damages because you weren't able to make rent payments isn't normally a part of compensation. That's where the differences are. And then you distinguish this hypothetical from your instant case. Though in this case, because of this factor, things would be different. Because that isn't the factor, because we are paying for more than just compensation benefits, this is clearly a punitive punishment from the NLRB, which does make this more similar to a common law cause of action. This is like really a punishment, not some agency from the executive making an administrative ruling. As you can see, it's a very clear kind of avenue you use when you do this first effort. The outcome is bad, but your rule won't allow it. And it's quite similar to how you discuss precedent, right? This is just the same as saying, well, in this case, this court decided differently. What makes things different? The second approach, if you have a size question, is to say your rule would allow it. Yeah, you're right. Under those circumstances, we would still win based off of our argument. But that outcome actually isn't that bad. Is kind of follows a very clear theme. Yes, it would lead to this weird outcome, but this court should not worry about it because either something else will prevent the bad outcome, or that outcome is not actually that bad. And because I think Supreme Solicitor General can deliver this argument much more convincingly than I can, I have two examples from a Supreme Court case, specifically on kind of the payments processes that I think illustrate both of these approaches. First off, for something else will prevent the bad outcome.
I'm just trying to understand the appropriations clause theory. Is there anything that would prohibit the president from the appropriations clause from deciding whether to take $0? And we've already established he could take $1 trillion.
I don't think the appropriations clause would be a check there, although of course Congress could then exercise its authority and its power over the purse to change the discretion that's provided to require the president or the director of the agency to take a particular amount.
So yeah, you see what she did there? You're right. The appropriations clause wouldn't prevent a president from, say, refusing to spend any money. But we don't have to worry about that because even though the appropriations clause won't do it, Congress has other ways of doing it. This past year, or no, last year, there was a case at the collegiate level about the Eighth Amendment and how it controls biometric information. And a very common hypothetical would be, wouldn't this lead to nobody ever having their internet protected? Or like, if this incredible case where something incredibly sensitive is on your phone and police access it anyways, are you saying the Eighth Amendment offers no protection? You're right, the Eighth Amendment does not protect this, but don't worry, we have a Fourth Amendment that will. The second thing, the outcome is actually not that bad, usually requires some form of like kind of breaking down what happens, but it can also be done really convincingly.
So let's say there's a law that allocates forever up to $1 billion adjusted for inflation to the FTC to use as the FTC seems fit. Would that be consistent with the appropriations clause?
So this is kind of a hypothetical that goes about, well, what about at the extremes? This current bill might have been only for a few $100 million, but what if we say $1 billion and the president has discretion on how to spend that? That clearly seems extreme, right?
So I think at the outset, if the law said however the FTC deems fit, it's not clear that would count as an appropriation because it's not clear Congress would have specified the purpose. But I recognize you can tweak it and say, to carry out the FTC's function. In that context, I think the hypothetical would effectively be a standing uncapped appropriation because, of course, the FTC would never reach that amount. It would be for a single agency, and we think that that is well grounded in history and, in fact, is how many agencies are funded today, particularly in the financial regulatory space.
Yeah, so if you can say, actually, yeah, and she actually starts off by clarifying, kind of on this first avenue, that actually the rule wouldn't allow you to say $1 billion for anything. They would have to be for a specific purpose. But then, no, yeah, that's fine. And we actually do have other historical examples of this court doing that. On these two ways, either showing that a rule won't allow a bad outcome, or that even if your rule would allow it, the kind of application of it won't lead to bad problems for the court in the future, are the best ways to tackle size questions. If it's a clarity question, you can sometimes draw a bright line in the sand. An example of this, kind of Eighth Amendment, no cruel and unusual punishment, and there's an argument here.
Line needs to be drawn for constitutional purposes.
I would draw it at 18, Justice Alito, because we've done that previously. We've done that consistently.
That's where you think the logic of your argument leads.
That's exactly right.
And you would say that a person of 17 years and 10 months, 11 months, who commits the worst possible string of offenses still and demonstrates great maturity, still cannot be sentenced to life imprisonment without parole.
In that case, the attorney's arguing 18 is a line. If they're under 18, any form of life without parole is a cruel and unusual punishment for a variety of reasons. You can draw that bright line, and sometimes that's what you have to do and just stick to it. That being said, there are going to be times when a bright line is not possible. And this is one of the places where it's okay to concede that, we don't really have a clear answer to this. You might say, Your Honor, we might lose if that was the case, if things really were in that stream. And that in this case, because of whatever reason, because we aren't at that level, our side prevails. You might say, we're not asking this court, or we don't know where the bright line should be drawn. Is never the perfect answer, but sometimes it's the best answer you can give, and judges understand that. I think a really impactful language to use there is that wherever the line is, it is clear that in this case, we are very much so on this side of it. A final note on hypotheticals. So the great thing about these questions is they really do talk about the core application of your argument and your rules. They're really discussing like what sort of future precedent your case might generate. So pay attention to them. If you encounter a hard hypothetical during a round, think about why that hypothetical was asked and what it was really getting at. Was it some form of there's something bad that will happen because was something bad that will allow the government to do because of your rule, or something good the government won't be allowed to do because of your rule? Or is it a question about, hey, how clear is your rule? What actually are the lines here? How should we apply it in the future? If it's about if your answer was clarifying the rule, saying actually that won't happen, or actually this is the line, or we can't really have a line, is there a way to kind of preempt that question when you originally introduced that prong of your argument? Um, if is there a way to preempt certain concerns about the size of your rule? Maybe make it explicitly clear pretty early on what sort of outcomes wouldn't be allowed under the rule versus why it's fine for your application to be used in this case and make sure your side wins. Um, and sometimes, if your answer to a hypothetical question does not please the judges, if you say, well, blah, 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 that'd be fine or whatever, it might be an issue with the case. It might be. There are going to be times when you have to have a legal rule because that's the argument you have to make to win. And it just is a weird argument that it kind of doesn't work at the French cases, but you need to accept that anyways because it makes so much sense in every other case. However, it could also be a thing of maybe rethinking your argument, either from day one to day two, making small adjustments, or if you are going to compete in a future tournament, kind of your first tournament into your latter ones. Um, these are really a great way to think about the structure of your argument and the way it works. I've been talking a lot about hypotheticals, so for final tips and tricks, just to kind of summarize things and leave plenty of time for questions if there are any. Speak slowly. When you feel like you are speaking at a slow pace, That's what you know. You only need to slow down a tad more. Everybody speaks too quickly. You will always speak too quickly. Speak slowly. You have so much content to get through. It's very easy to kind of rush through it. But us judges, we don't know this material as well as you. We know it well, but no one knows as well as you do. And when you do slow down and kind of walk us through it, we're able to really understand the argument you're making, and it impresses us. Because it is so hard to remember to speak slowly, take a pause before answering a question. Mentally thinking to yourself, every time I get a question, or every other time I get a question, I'm going to take a second to breathe. This gives you time to process what you're thinking about to make sure that the first answer you give is the best answer you could give. It also is a mental reminder for yourself to slow down. It is very easy to start off slowly when you're giving your introduction and roadmap, and then to speed up and speed up and speed up, and you're being asked questions and your time is running up and you speed up. So take a breath, slow down after receiving a question, especially if you've been being badgered. That also cues us judges in to let us know, oh, we've been pushing them a lot. We need to slow down. We need to like take a second to breathe for a bit. So it kind of mental reset for both parties. Eye contact. Eye contact is a great thing to practice. Practice, um, Practice using eye contact even when your judges aren't using you, looking at you. A lot of our terms are virtual, including the beginning one, so this will be a less of a problem there. But if you ever do go to an in-person tournament, there's a chance a judge will be staring at their computer the entire time, typing, trying to hear what you're saying and taking notes. If you're able to still kind of look under direction or look at where their eyes would be, despite them not looking at you, that is great practice and it really develops your forensic skills. On that note, practice giving a speech to an empty room looking at inanimate objects. Pretend like a lamp and a water bottle are judges. Practice varying your eye contact between them. Just get into the rhythm of changing eye contact between people and being used to kind of looking at people and observing them, but not staring directly at them, and being comfortable with them when they aren't looking at you. And finally, practice how to handle all types of benches. From cold benches, when you have one question asked, maybe two, to hot benches where you're being asked things constantly. I would generally recommend if you have time before your tournament, take some time to maybe 1, 2, 3, 4 days to just stand in an empty room. It could be your bathroom or you're getting ready for school to just give your 10-minute speech, 9-minute speech, however long it is, straight through, no questions, and just see how it feels. Are you able to fill an entire 10 minutes without questions? Likewise, if you guys have a team, you could consider practicing with a very hot bench where you're being asked a question every 20 seconds and see if you can still adjust to that pace. Finally, if you can get non-moot court friends and family to help you practice, if you can get a parent or a sibling to ask you questions while you give your speech, that is such great experience. You guys are amazing at this. You're doing so much preparation in your clubs and classes. Once you start doing these things with the activity with the same people, though, it's very easy for consensus to form. These are the kind of questions we ask. These are the kind of things we care about. These are the things we focus on. And that might be very different from what an actual judge will focus on, especially if the judge isn't as familiar as this case with you. Getting a random person both gives you a fresh perspective and make sure you can explain your case to somebody who's hearing it from the first time as easy as you can to somebody hearing it for the 100th time. With that being said, thanks for being here. Are there any questions?